Hi everyone, so welcome back to our tutorials on non-fatal offences. We are now going to start part 2 to continue learning about the areas of law. So at the end of part 1 I showed you briefly how to answer a short scenario on assault and battery. So I'm now just going to pick up on where we left off there, and this scenario was requiring you to advise Sandra of her liability for non-fatal offences in relation to Tara. So we started off by looking at the first incident of Sandra shouting over at Tara and threatening her. So we'd identified that Sandra potentially commits assault here, charged under Section 39 of the Criminal Justice Act 1988. So the act that she's committed is the use of verbal words in order to threaten Tara, and we can evidence that from the case of Wilson being verbal words. So she clearly intends for Tara to fear unlawful force, but remember there were two issues. So the first being that the assault may not be considered to be immediate because she uses words that actually negate the immediacy of the threat, where she says, if it wasn't so hot. So we can apply the principle from Tuberville and Savage and say potentially the assault isn't of immediate unlawful force. But the other issue that I asked you to identify after the tutorial was here, that I've put in bold, whether she actually fears. So remember, for an assault, the act must cause the victim to fear or apprehend immediate unlawful force. So arguably, based on the facts in the scenario, Tara doesn't fear because the scenario tells us that she walks off smiling. So what we have here are two elements of the offence of assault that potentially aren't made out, therefore meaning, in conclusion, that Sandra may not be potentially liable. What I've also done on this slide, which I would like you to write down, is a brief application of one of the battery incidents in the scenario. And this is where Sandra runs up behind Tara and grabs her hair. So I've identified this as being a battery, again charged under Section 39. It is unlikely to be an assault as well because she grabs Tara from behind. So there doesn't appear to be any fear of immediate unlawful force. If you attack a victim from behind and they don't know that you're approaching, and there's nothing in the scenario to suggest that she knows Sandra is approaching, then that would indicate that that is purely a battery, so the application of unlawful force. So force can be applied directly or indirectly, and here I recognise it's direct through the hair pulling. The force is unlawful, so there's no indication of a defence being used here to make the force lawful. On the note of applying force, remember that force can be slight, so you could add that principle in here, and that can come from Collins and Wilcock. Also, you might want to look at a case called Thomas online, where the touching of a hem of a skirt was actually deemed to be application of unlawful force. So touching could be force as well, so just be aware and make sure that you identify what the force is. Going on to the mens rea, Sandra clearly has intention to apply unlawful force, and that's through nature of her actions. You know, this isn't a reckless act, a realisation of a risk. This is the act being Sandra's main aim or purpose, to apply unlawful force to Tara. It comes from Moen, and therefore making her guilty of battery. So I hope that helps you to form some kind of a structure, and I will be setting you an exam question that will require you to apply these in the near future. So let's move on to the next level up of non-fatal offences, and the next level is the occasioning of actual bodily harm. Now, occasioning basically means causing. And what the offence is, we tend to, in layman's terms, just say assault occasioning actual bodily harm. But it's actually, if you look at the legislation, section 47 of the Offences Against the Persons Act here, so make sure you recognise this is a different piece of legislation now as we get into the more serious offences. The offence itself is actually an assault and or battery that occasions actual bodily harm. So we need to make out the law for the lower level offences first, and we need to work out what constitutes actual bodily harm. Think about this as a layering effect. We work out or identify whether there's an assault or a battery or both, which would be a common assault, and then we work out what the injury is. If the injury is of a greater level than that required for a common assault, then we could charge actual bodily harm. And it's interesting to note that this not just being a triable either way offence, so it is quite wide ranging, could be from any more than what we say in practice a good bruise up to a fractured nose or a broken bone. But because it's wide-ranging, the sentencing is quite wide as well. You could receive a maximum of 5 years in prison for this. So we see the sentencing jump for common assault for 6 months up to 5 years for ABH, which is a criticism actually, because when we start to look at the legal elements, you will see that the mens rea is no different for an ABH. Purely what makes an offence an ABH is the injury. Okay, so it's an offence to commit any assault or battery occasioning actual bodily harm, and that does mean causing actual bodily harm. So it has the same actus reus and mens rea as common assault, but ABH injuries are caused. So we need to really, in a scenario, be looking out for what the injuries are and making a judgment on which level offence we're going to charge before we apply the law. So what does ABH actually mean? So there have been some older definitions that have been bandied about, and the first attempt to define actual bodily harm, because the legislation is quite silent on this. In actual fact, the Offences Against the Persons Act is really not useful and quite outdated, and it gives rise to quite a lot of criticism, which is useful for an essay. But given that Parliament would like us to charge actual bodily harm and give defendants a maximum sentence of up to 5 years, we need to, as the judiciary, decide and determine what ABH actually means. So there was an older definition which defined ABH as any hurt or injury calculated to interfere with the health or comfort of the victim. So that was initially decided in the earlier case of Donovan. Donovan was initially convicted of ABH at trial based on causing bruising to a 17-year-old girl. He was an adult. He was caning her for her and his pleasure. He actually claimed that she consented to the caning. Now, he was convicted at first instance, but on appeal he was actually his conviction was quashed, so he was found not guilty in the end. But on appeal, the Court of Appeal took the opportunity to define what they meant as ABH. So just thinking about this definition for a few minutes, it is quite wide. Any hurt or injury calculated to interfere with the health or comfort of the victim. I mean, you could argue that a paper cut interferes with your comfort, so it really isn't a useful principle of guidance. So no wonder we rely so heavily on guidance from the police and the CPS for the charging standards, because they give us some practical examples of what will constitute an ABH. So please do make sure you look at those in your booklets. So then we get to 1994, where the case of Chan Fook, and this was a Director of Public Prosecution's case in the end, so an important one, where they took the opportunity to define ABH as basically not being trivial. So I don't know whether you believe that that helps anymore. And the facts are here. So Chan Fook subjected the victim to questioning about the theft of a ring belonging to his fiancée. He dragged the victim upstairs to a room and locked him in. The victim feared the Chan Fook, the defendant's return, and injured himself when he fell through a window. Now, if we think about previous cases that we've looked at in relation to causation, remember causation will always be an element in a result crime such as this. Chan Fook could, of course, argue, well, I didn't cause the victim's injuries. He fell through a window. But if we apply the tests, the but-for test and the more than minimal cause, we can find Chan Fook liable here. So undoubtedly, that would have been an issue raised at trial. Of course, do the victim's actions break the chain? Well, they are foreseeable. If we look at cases like Marjoram, which are very similar facts to this, although a later case 6 years later. If we look at the case of Roberts some years earlier, where these victims make a decision to remove themselves from situations of danger, we find those actions foreseeable and they do not break the chain. So Chan Fook was guilty, but also on appeal, what was updated was the definition of ABH, so not being trivial. Make sure you highlight that bit at the top here. But secondly, they also widened the definition of ABH to say that it includes psychiatric injury. So if you commit an assault, then what you're doing is you're causing the victim to fear or panic, and this is arguably a temporary emotion that goes away. So you fear maybe a threat initially, but that should go away. But where this might actually indicate further injury that needs to be charged may be where fear or panic develops and turns into something more serious. So you might end up suffering with depression, fear of going out in public for being harmed. And that's where we have this concept of psychiatric injury. Of course, we need expert evidence, but potentially, depending on how serious this is, it could even be charged as a GBH, which we'll look at a bit later. So just bear in mind, if a victim is suffering from fear or panic, if it's temporary, that will be an assault. If it's more serious and becomes longer lasting, and maybe they develop a clinical condition as a result, like depression, then that could be charged as an ABH or even a GBH if the depression becomes serious. We're always looking out for those key descriptor words of where we should charge in the hierarchy. So this ABH is a mid-range level of offences. The mens rea of ABH, and it's really important that you listen carefully to this, is the same as assault and battery. There is no additional mens rea required to have caused the ABH. So you do not need intention to cause ABH injuries or recklessness to cause ABH injuries. All you need is the intention or recklessness to apply unlawful force for the battery or to cause the victim to fear for the assault. If the result of the action is an ABH level injury, that would then be charged as an ABH, but there is no mens rea required for that higher level injury. And that principle actually comes from the case of Roberts that I mentioned a few minutes ago. So you'll remember the facts of this. We looked at this in relation to causation. Did Roberts cause the injuries of the victim who jumped from his car when he was trying to take her coat off and was touching her leg? Now we know that he was guilty, and luckily she didn't die when she jumped from the car, as unfortunately did happen in the case of Williams and Davis with the hitchhiker. The victim suffered ABH injuries. Now, Roberts argued, in addition to, I didn't cause her injuries, she decided to jump, she acted unreasonably. He also argued that he didn't have any intention to cause those injuries. And of course, what the court said was, you do not need to have the intention to cause ABH. All you need to have intended or have been reckless to do was to commit an assault and or battery. So by touching her, and by saying and doing things that are causing her to fear, he has the relevant mens rea for those lower level offences. Of course, the injury is the added layer of actus reus, and I hope that that makes sense to you. So he didn't intend these injuries, but he had intended to apply unlawful force when he touched her as he tried to take her coat off. Okay, so you do have the charging standards in your booklets, but also on the slides I do give you the injuries, the outcomes that we're looking for in charging an ABH. So minor fractures, extensive or multiple bruising. So there is always an overlap, and I remember in practice we used to have arguments about whether injuries were a battery or an ABH, because of course it means the difference for a defendant client of time in prison ultimately and level of sentence. So it is an argument that always happens, and don't be worried if you feel that injuries could be in one bracket or another. If you're unclear, always talk about both so you can give a justification, because bruising, if a victim suffers one bruise, then that could be a battery rather than an ABH. So we're just looking at roughly what do we believe that these injuries would constitute. Small cuts that require stitches would be ABH. Loss of consciousness, make sure you underline this one because this is one that comes up in scenarios quite often. Even if a victim blacks out momentarily, as in this case where, not a very nice case, a minor was being beaten up by a number of slightly older youths, and he did black out momentarily, that was deemed to be ABH. So loss of consciousness is ABH. Obviously, if that loss of consciousness turns into a more prolonged period of incapacitation, like being in a coma for a period of time, then that could be charged as a GBH. Psychiatric injury, as we've already discussed, would be charged as an ABH. And any illness as well, so anything that occurs secondary from that initial injury, so depression would be charged. Now, the case of Burstow is a really good example of a defendant who was charged with causing illness to a victim. Now, illnesses are obviously more difficult to prove because they generally don't show physically, and of course you will need expert evidence, so you'll need to pay for an expert to come to court. If a court believes that an illness is evident, then it has the ability to appoint an expert itself, which of course comes out of the criminal justice pot of money. But if a defendant is wanting to counter an argument for illness being there, then they may want to pay for their own expert, and then what you might have are a number of experts giving evidence at court, all giving different perspectives, so it can get quite tricky. Now, Burstow had a relationship with a woman and she ended the relationship. He couldn't accept that, so he started harassing her. He was making abusive telephone calls to her, silent telephone calls, taking photos of her, sending hate mail. All of those actions indicate assault at the lower level. And if they were just causing her to fear and temporary distress and panic, then of course we're looking at assault. so a summary-only offence. But what happened here is that the victim, over a prolonged period of time, actually suffered with severe depression and was diagnosed with that, and that was accepted by the court. And note that I've said severe, so actually in the end, Burstow was charged with GBH, Section 20, on the basis that his actions had caused her to have severe depression. It's really weird to categorise depression in that way, but had it have not been severe, then it may sit in ABH instead. So just look out for words like serious and severe, because they can indicate actually the higher level offence there. And I like this one, although I'm sure the victim didn't. Cutting off hair was deemed to be ABH in this case. So note this is a DPP v Smith case again, but we can put Michael in brackets to distinguish this from the earlier DPP v Smith case that you learnt through your murder lessons. Now this was a case where an ex-girlfriend turned up at Smith's house whilst he was asleep and woke him up. He pushed her onto the bed, obviously they had a bit of a fight, and he cut off her hair, which was in a ponytail. No other harm to her was caused, so she had no bruising, cuts or anything like that. Now he was not guilty at trial, but the prosecution did appeal that, and this went to the Queen's Bench Division. So obviously DPP there involves an important point of law that he wanted to prosecute on. And what the Queen's Bench Division said was that bodily harm includes all parts of the body, including hairs on your scalp. So they actually said that this could constitute an ABH injury, which is really interesting. So look out for those types of injuries in a scenario, and you could apply not just the law of assault and battery, but also the added layer of ABH. Make sure you define it and then identify which injury is ABH level. Okay, so moving on to grievous bodily harm and wounding. So types of injuries we're looking at with this higher level bracket are anything permanent or serious. So disfigurement, disablement, broken bones, including a fractured skull, injuries that cause a substantial loss of blood, usually needing a blood transfusion, injuries resulting in lengthy treatment or incapacity, so rehabilitation, time in a coma, serious psychiatric illness, as we know from Burstow, which ended up being a GBH charge, transmitting of life-threatening illnesses, and this defendant here was charged with transmitting HIV to a number of victims. Now, we have to, of course, as well identify what the intention of the defendant is, and in this instance, he didn't intend to transfer that illness, rather he was being reckless. He had an idea that he did have the illness and transmitted it, and there are lots of discussions around which illnesses should be actually prosecuted for. I know that the Law Commission had suggested that CPS prosecute for transmission of chlamydia, which is a really common STI, but that was rejected because, of course, they say, or statistics say, that 1 in 10 people could have it in their lifetime, and some people display no symptoms. So then what you get into the realms of are prosecuting people, and the difficulties and the cost in proving those convictions can be quite problematic. So this type of injury is usually reserved to the most serious types, and something like HIV is life-limiting and life-threatening. So just watch out for that. It doesn't include all illnesses there. Determining whether an injury is grievous as well, we have to take into account the effects on the victim, and this comes from a famous case of Bolam. Now, Stephen Bolam, I remember this being in the news in 2003. He had caused injuries to the basically his stepdaughter, so 17-month-old daughter, so a year and a half old, really sad, of his partner. He'd caused her bruising and abrasions, which are obviously scraping of the skin, essentially, kind of superficial cuts. Now, on an adult, these would have been ABH injuries, wouldn't they? Multiple bruising, cuts, abrasions, these would have been ABH. But because of the effect that they had on a younger victim, Bolam was actually convicted of causing grievous bodily harm and with intent. So that made a significant difference to his conviction and sentence in the end. So just be aware of who the victim is, and if they are particularly vulnerable, so if they're elderly or really young, then just take that into account when you're deciding what those injuries should be charged. So note that I've been using the terms grievous bodily harm and wounding. We need to make sure that we understand the difference. In terms of what we charge in the legislation, Section 20 or Section 18, a wound or a grievous bodily harm injury is an academic difference. The difference between a Section 20 and 18 is the mens rea, so the intention of the defendant at the time. But the way these injuries are inflicted, that's the difference between a wound and a grievous bodily harm. So this is simply an actus reus point. So a wounding will be committed where you break the inner and outer layers of the skin. Internal bleeding will not be considered a wound, and this comes from a case of Eisenhower. It's a nice way to learn it because it's about an eye, so you can think Eisenhower eye, and this is where rupturing of blood vessels in the eye was not a wound. Now, wounding, therefore, could be caused by actions like shooting or stabbing, something where you are breaking the skin and the victim bleeds. And of course, to charge this higher level, we must have substantial loss of blood, if you remember. So we are looking at something quite serious there. On the other hand, a grievous bodily harm injury would not be something that necessarily causes bleeding. It could be broken bones, fractured skull, something internal that's really serious. And this comes from the case of DPP v Smith, which you will recognise from your murder lessons. So you will remember the facts and remember that this actually ended up being a death. So we had a murder charge here, if you remember. But in deciding what the mens rea was, whether the defendant intended to kill or cause serious harm, the House of Lords, as it was then, took the opportunity to define what was meant by really serious harm, because of course by law we call that grievous bodily harm, and they actually did, not very helpfully, just say it means no more and no less than really serious injury. So once again, we go back to our charging standards. Well, what does that look like? And I go back to the fractured skull, the disfigurement, the disablement, those brain injuries that people suffer. They don't kill you, but they will give you long-lasting incapacity or needing lengthy treatment, and that would indicate a grievous bodily harm. So just make sure if you see reference to blood, make sure that you determine whether it's a wound or grievous bodily harm first of all. So determine the injury and then apply from there. So as I said, the difference between Section 20 and 18 is really to do with the mens rea. Interestingly, there are some differences in terms of wording, and we don't know why, because Parliament legislated these in 1861. Nobody is alive from then, so we can't ask them, well, why did you use different words in these sections, when we don't understand the reason behind it. If you go back to, everybody has a sheet with all of the criminal offences on it. We looked at these at the end of Principles of Criminal Liability. You will have the offences on here. So make sure you go back to these in your folders and look at the wording, and you'll see that section 20 of the Offences Against the Persons Act says that a defendant is guilty if they inflict grievous bodily harm or wounding on another, whereas section 18 says that a defendant is guilty if they cause grievous bodily harm or wounding to another. Now, we know that there is a difference between grievous bodily harm and wounding, but in actual fact, the courts have said there is no difference between inflicting the injury or causing the injury. Now, I don't know whether you agree with that, but the court in Burstow actually took the opportunity to clarify that. So don't kind of get waylaid by, is there a difference? There isn't. We just determine whether the defendant has committed that act, caused those injuries, and that's it. I would imagine there was a difference that Parliament intended, but we don't know what that difference is. So we, as the courts and as people applying the law, don't treat those wordings any differently. The mens rea, however, is different. And we have, for section 20, if you remember when we looked at these offences on the offences sheets that you all have, the word maliciously features in section 20. And this means intention or recklessness. Now, for section 20, you only need to have basic intention or recklessness to cause some harm. So please write down at the end of this sentence here, if I use my mouse, to cause some harm. The difference has to be really clear that section 18 is to cause intention, to cause serious harm. So if we can evidence that a defendant has caused serious injury through grievous bodily harm or wounding, and they intended to cause that serious injury, then we can convict them of section 18. What is the difference? The difference is a discretionary life sentence, maximum life imprisonment for section 18. Whereas for section 20, interestingly, the maximum sentence is only 5 years. The same as ABH. That is a big criticism. The Law Commission have suggested that we increase that sentence to 7 years for section 20, because of course, what is the difference? If you are going to be given the same potential maximum life 5-year sentence rather. But for section 18, the jump to life is based on the mens rea. Remember, this mens rea is the same as what could be required for murder. If you end up killing somebody and you only intended to cause them serious harm, you would be guilty of murder. So the distinction here is based on the mens rea, and that gives the greater sentence. Okay, so we have some practice here. I know I've gone through a lot, so do take time to summarise, and I will send you all a summary as well so that you can use that. So do please ask me if you don't receive that. There is quite a long scenario here. This, under the old OCR, would be 50-mark scenario, but I've split it into 3 parts for you to make it a little bit more manageable. So I would like you to have a go at practicing this, because it's really important that you get as much practice as you can. Feel free to send me your practice to Mark. As I say, I will be setting you an exam question, a current exam question, at some point in the near future, but practice makes perfect. So have a look at these 3. You have this scenario in your booklet, so just make sure that you number the different areas on your scenario so that you can split it up and identify the offences that have been committed. If we just go through, we look at, in the first scenario, we look at text messages, threatening, and then we look at how the victim becomes distressed and is provided medication to calm nerves. So here we could have an assault. We have to consider whether those injuries stay at assault or whether they become an ABH. Secondly, we have a victim who sees somebody looking through the window. Sounds familiar to a case we've looked at, doesn't it? In a panic, rushes to the kitchen, smashes his head, knocking him unconscious. So again, is that going to be an assault, or is that going to be an ABH based on the loss of consciousness? And then thirdly, we have an incident in a hospital ward. If I can't have you, then no one can. And then a stabbing in the chest, puncturing a lung, but no death. Of course, remember, this is non-fatal offence time. So that puncturing a lung caused by a stabbing, what level injury is that going to be, especially where the victim doesn't recover for several months? So hopefully that gives you a good indication of how those can be applied, and I will take the time to go through those with you in the next part. If you would like additional practice, there is another scenario here that you will have in your booklets, and again I've identified the different incidents through the different colours here, so make sure you go through and number those. So we have a tackle in a football match forcefully, which causes bruising. We have a striking of a head on the handlebars, suffering a long, deep cut to a face. And then we have a note on the windscreen, which is threatening, which then ends up with a mild neck injury. Now, the first part in green could actually give rise to a potential defence, and we will look at this again during one of your next parts. But it might be worth initially having a think about what that defence could be where they are playing during a football match. Okay, so next tutorial we'll cover defences, and I will spend some time going through some application with you as well, and I hope you found this session useful. That's all for now. Thank you.